Court is resumed. Please be seated.
Thank you. Good afternoon.
Good afternoon, Your Honor. I'd like now to turn to the second point I indicated I wished to develop. I called that the past binding judicial determination point. And when I was summarizing them to you, I said that there are a number of judicial determinations which tell us and guide us that sections 111 and 112
Yes, I see we're stuck at the cliffhanger.
appropriately so. With Kamal, Rainer? Now shut me out entirely. Is that part of it rebooting? Booted me out again.
Yeah.
I do it. I have it.
Yes, yeah, thank you. Not waiting for me, no, it's like 10 something. Yeah.
Are we ready?
No, I'm good. Yeah, that's on the text message here.
Oh, excuse me.
Yeah, sorry, apologies, that was me.
Your Honor, are you ready?
I'm ready.
It seems we all thought we were still waiting for tech problems, but that we're ready to proceed.
It came through. When you're ready.
Thank you. That time has actually given me a moment to collect my thoughts a bit, and I'd like to actually step back and to give you the submissions or the paragraphs in our main submissions for the financial deal argument that we make. In our main submissions, Your Honor, you'll find our argument beginning at page 64 through 70. We set it out at 64 through 70. The argument really begins at paragraph 233 and following up to 245.
Thank you.
And with respect to section 142 in particular, you can find our position on that at paragraph 75 of our main submissions. Thank you. All right, once more from the top. Before lunch then, I had taken you through the provisions of the Constitution and had reviewed with you the testimony that you heard about the new financial deal that had been struck. Over quite some time, the negotiations took place over 10 years or so, and how it made, we say, Canada directly liable for debts and liabilities, contingent and otherwise, that the UPC came into Confederation, came into the Union with. So they were now the person that was to satisfy those debts and liabilities. And then I told you that I wished to look at the past binding judicial determinations, which conclusively held that sections 111 and 112 do in fact govern the responsibility for increased annuities and direct payments responsibilities for those. And we say that the various arbitrations, including the arbitration of 1870 and the statutory arbitrations that took place beginning in the early 1890s and through to 1900, respecting the accounts of the UPC, are relevant to what the tasks you have today. And they're as applicable today as they were when they were made. Most importantly, they're as binding today as they were when they were made. I plan to develop submissions about why they are legislatively binding and how they are also binding according to principles and doctrine of common law. So I want to start with our position that Canada is legislatively bound by previous judicial determinations. And the first I wish to talk to you about is the award of 1870. That award is a final award. You did hear evidence about how the validity of it was challenged to the Judicial Committee of the Privy Council. It was found to be a valid award. It stands. And in fact, in 1898, the Supreme Court of Canada, sitting on appeal of a decision respecting the common school funds, which of course was something that we've also touched on briefly today. It was also an issue to be divided. The Supreme Court of Canada unanimously held in 1898 that the 1870 award of the constitutionally appointed arbitrators under Section 142 of the British North America Act, their award had constitutional status, as if it was itself embodied directly into the British North America Act. We provided a citation for that. It's the province of Ontario and the province of Quebec versus the Dominion of Canada, and it's found at tab 29 of our compendium. And it's page 816 of the Common School Funds case. Now, I actually don't think that that is a contentious point between Canada and Ontario, because at paragraph 71 of Canada's statement of defense against the plaintiffs and cross-claim to us, they plead the decision of the arbitrators, speaking of the Section 142 arbitrators, forms part of the constitutional financial arrangements made at the time of Confederation. I've quoted directly from that, but it is at compendium tab 30, paragraph 71 of their pleading. Now, I will hasten to say that in that portion of their pleading, they're discussing a particular clause of the award of 1870. We say you can't choose what portion of an award is binding and disregard the ones that are not. If the award of 1870 is part of the Constitution, as the Supreme Court of Canada tells us, then the entire award is, not just the portions that you may choose. Now, I thought it would be appropriate if we looked at the award of 1870, because there's two clauses that are significant for stage 3. The first is clause 1, and if we turn to tab 27, we have here the award of 1870. Now, you might recall, Your Honor, that there was a number of matters in the statement of account that the Dominion General Auditor, John Langton, had prepared and had been put before the Section 142 arbitrators. They were dividing the debts liabilities, assets, and property of the former UPC and dividing it between what are now the new provinces of Ontario and Quebec. That was what was tasked to them by the clear language of Section 142. But the provisions that are relevant for us are clauses 1 and 13. 1 is at page 116, again, my numbering. And this is definitely something that I will try to paraphrase for you. It says, or here we see, the language or the apportionment of the percentages that people keep telling you about. It's not expressed as a percentage here. Nobody will tell you that. But we see the allocation of the UPC's debt. And there were some questions about how that all arose. You asked my friend on Friday. And I recall your exchange, and I'd like to take a moment to take you through what the evidence of Ms. Jones was in that regard, because I think she expressed it quite clearly. In her report and in her testimony, she explained that the Section 142 arbitrators did not apportion debt on who received the benefit. That was not a benefit analysis that they were doing. The responsibility, the liability follows the benefit. And she told you that, in fact, they had abandoned such an approach precisely because not every debt had an asset or a benefit that they could attach to it. So they took a more nuanced approach. And I've tried to take what she described in her report and her testimony and put it in my own words. They looked at each debt and tried to determine if it was something that was clearly for a local purpose within the boundaries of the new provinces. So for example, the way that I think about it is if there was a debt for constructing a new government building in the city of York, now Toronto, the city of York, that was very clearly something that was for the local purpose of Ontario. And they took that amount and they applied it on a ledger that said Ontario. And they did this for everything they could that was clearly of a local purpose, one or the other. And once they did that, they added it all up. They added the Ontario column and they added the Quebec column. And you'll see the numbers that they got to in this clause. So the said I'm reading from the middle. The said province of Ontario shall assume and pay such a proportion of the said amount as the sum of $9,808,728.02. And they do the same thing for Quebec. The sum of 8 million, pardon?
We can skip the amount.
Okay, perfect. That makes me very happy. The point that I want to make is they do this exercise and they add it all up and they say, okay, this is Ontario's, and okay, this is Quebec's. And then they total it together and they get this amount of about $18 million, roughly. And then with respect to those things that don't have a benefit or an asset, they say, what do we want to do with these? Or what things are not just for a local purpose? And that's when they say that the proportion, so that allocation, that ratio that gets used, we're going to use that across the board, even though we can't put these other additional leftover things in either of those categories. And Ms. Jones's evidence, and again, you'll find it at tab 35 of our compendium. And in particular, on this point, it's at pages 155 and 156. So don't just take what I'm describing to you, read what the evidence was by the expert. Her evidence was that the Indian annuities that were also part of that statement of account that was put before them, it was not something that they could assign for a local purpose, but it did get that apportionment as one of those things that wasn't just a local purpose, but they would apply this ratio to. So that's how, I hope, in answer to your question, how did they figure this out? Where did these numbers come from? That's what they were doing, was what Ms. Jones's evidence was. Now, the second significant clause of award of 1870, September the 3rd, 1870, is clause number 13. It's at page 119. Just waiting for it to come up. Okay. And this is the section where this section 142 arbitrators determined that Indian annuities without limitation form part of the debt of the United Province. So this was one of the arguments that were before them, and in particular raised by Quebec about whether or not this should be a debt at all that was on those statements of accounts that were to be divided and apportioned and charged to the UPC account. And Quebec made the argument based on a Section 109 argument, because most of these annuities, not just the Robinson ones you'll recall, but the annuities were in Ontario. And the arbitrators said, no, we're putting this in as part of the debt to be apportioned between you. Now, I say without limitation as to the amount or the type of Indian annuities, because the language in clause 13 includes no limits or caveats. It talks about the annuities that were given in consideration of lands surrendered are to be included in the debt of the late province of Canada. So by including it in the debt of the late province of Canada, they are necessarily putting it in the 111 basket, because 111 is what's dealt or dealing with the debt of the province of Canada. And by virtue of putting it in the 111 basket, 112 may apply. And I also say it's without limitation to amount or type of annuity, because the Supreme Court of Canada in the annuities case said that the award of 1870 was not limited to fixed annuities. So if we turn to tab 28, the next tab over, and we look at page 507.
Which is your page 124.
Oh, excuse me. Yes, thank you.
Thank you.
So at my paging 124, we see this is the Chief Justice of Canada, Justice Strong, saying, there is nothing before us. Excuse me.
This is what case?
This is the Supreme Court of Canada annuities case.
Thank you.
This is the appeal from the paragraph 6 of the award number 3 of the statutory arbitrators. And it's December 1895.
Thank you.
This is the decision that split 3-2. Chief Justice Strong and Justice Sedgwick both wrote reasons concurring in the majority, and Justice Taschereau joined them. Chief Justice Strong, there is nothing before us to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made their award. He goes on to talk about the terms of the 142nd award. It was within their terms to decide such matters. And he continues at the next highlighted passage, same page. It must therefore be intended that having before them the treaties and the Act of Parliament under which they acted, the Constitution, they decided as a question of law that the increased annuities were not charged upon the surrendered lands, and that there was no trust of these lands for the purpose of paying the annuities. And therefore, they were a 111 debt. Now, I say that Canada is also legislatively bound by the decisions of the statutory arbitrators and the final decisions from them. And I started to make this point with you earlier today because it relates to what I call the Act of 1891, respecting the settlement of accounts between the various governments. And that's at tab 2. We can look at that again. It might be convenient to do so. If we turn to tab 2, and at page 15, it talks about the effect of the awards at section 8. And it says that the appointment of the said arbitrators and their award in writing shall be binding on Canada, save in case of appeal on question of law, in which case the final decision thereon shall be binding on Canada. So we say then that awards made by the statutory arbitrators that are final and in writing are binding. They're binding by legislation. They're also binding by common law principles, but they're binding by legislation. Portions of those awards that were appealed, they're also binding because they're legislatively binding as a final decision. So where the Supreme Court, or in at least one case, the Judicial Committee of the Privy Council has made a final award, final decision based on an appeal of an award, Canada is bound by legislation to those awards because of their legislation still in effect today, and that was in effect when those awards were made and when those decisions were made. So let's start with award number 3. Let's break it down. What is Canada legislatively bound by because of Section 8? First, consider paragraph 4.
Section 8 of that enabling legislation?
Yes, that the statutory arbitration decisions were made pursuant to.
Go ahead.
So we looked earlier today at award number 3. The tab 6. Don't propose to turn it up. I think I can summarize it for you again. It was one of the things that you asked me to put in my own words, and it had 2 paragraphs that were relevant for the discussion I'm having with you now. Paragraph 4 and paragraph 6. I want to talk first about 4. 4 was the one that dealt with pre-Confederation liability.
Yes,
You'll find it at compendium tab 6, Your Honor.
page 26.
I think that's right. Yes, thank you. So paragraph 4, I paraphrased to you, I believe in these terms. I said that that dealt with the pre-Confederation.
Yes,
And it went on to say as well, sorry, Ontario and Quebec, the deal for settling that you thought you had for $88,000 to not have any further liability to Canada for annuity payments under the Robinson Treaty, that's not what happened. Similarly, your argument about the Act of 1873 didn't affect that result either. Right? That section, that paragraph, is the final decision on pre-Confederation liability of the statutory arbitrators. That section doesn't get appealed. So we say that's binding. It's a final decision of the statutory arbitrators, and the enabling legislation says that the final award in writing is binding. So that section, that's easy to deal with. And I don't think that that's a point in contention either. You'll be happy to know, because of paragraph 309 of Canada's main submission, it concedes it has liability for pre-Confederation augmented amounts. I don't think they refer to that section, but perhaps that's what they had in mind. I don't want to suppose, but that concession is there at paragraph 309. Now, paragraph 6, that's what I paraphrased you as dealing with post-Confederation matters. It said, statutory arbitrators said, Section 109 applies to everything post-Confederation. Ontario has the land, Ontario has the responsibility and liability. But that's not a binding decision. That's not the final award on that point, on that issue of the statutory arbitrators. That got appealed. It was successfully appealed by Ontario. That's what the Supreme Court of Canada's December 1895 annuities case dealt with. Ontario won at the Supreme Court of Canada, as you've heard. Quebec and Canada appealed that decision to the JCPC in England. The JCPC upheld the Supreme Court of Canada's decision. So it's those decisions, Your Honor, that say that 109 doesn't apply to post-Confederation. Those are now binding. They may be binding as well, I would submit to you, because of res judicata and stare decisis, and I will explore that with you. But they're also legislatively binding because the award in writing was binding unless appealed, and the final decision on appeal was then binding.
Yep.
So then, what does that decision say? What do those final decisions say? Well, first and foremost, they say that Section 109 didn't apply. If we go back to tab 28, that's the Supreme Court of Canada annuities case. And we look at the conclusion of Chief Justice Strong's decision, page 125, my page numbering. We see the Honorable Chief Justice saying that the appeal that must be allowed and the award must be varied. The award of the arbitrators must be varied by substituting for the 6th paragraph the following. The ceded territory mentioned became the property of Ontario under the 109th section of the British North America Act 1867, absolutely and free from any trust, charge, or lien in respect of any of the annuities, as well those presently payable as those deferred, and agreed to be paid in augmentation of the original annuities upon the condition in the treaties mentioned. Now, that award also struck out, the Supreme Court of Canada's decision also struck out paragraphs 7 and 9. Those were matters of interest that related to what would happen if Ontario was being charged the full amount. So paragraph 6 fell, therefore the other provisions fell, the other sections fell as well. What else did the Supreme Court of Canada hold? It held that there was no latent lien or trust created. It had language that would not have been intended because it would have fettered settlement. It held that the treaty did not create a security interest in the land or the proceeds.
I don't think the content of what they said is controversial. So what you want to focus on for me is the import.
Okay. One of the import that I'd wish to focus on then is something that my friend said yesterday. One of the things that the Supreme Court of Canada said was that the treaty beneficiaries, the annuitants, had the security of a charge on the CRF, and essentially that the government was good for the money. That's what I'm paraphrasing here, what the Supreme Court said. Probably the richest nation in the world at the time was good for the money, that an additional charge of some sort was not required. And my friend said sort of the same thing yesterday about speaking to you about banned trust account rates. And she said that banned trust account rates wouldn't have been necessary because the annuitant's right is legally enforceable in the court. Their right will be vindicated in the sense that they don't need to worry about never seeing the money. It's guaranteed by the government. And that's exactly the point that Chief Justice Strong was getting at in his decision also. Now, Canada has claimed, relying heavily on Professor Messamore's testimony, that the courts only considered annuities up to $4, and thus the binding nature of Award 15, or rather the Supreme Court of Canada case, relates only to a $4 annuity. But that's not supported when you read the decision itself. And I was thinking of Your Honor's words, don't know now if it was yesterday or Monday, about the hard work that needs to get done. And one of the hard things that needs to get read and understood is what these cases say. And I can go through this case and I can pick out portions that say this or say that and dispute what my friend has said. But what is very important to understand reading these cases is that the Chief Justice's decision in particular, but also Justice Sedgwick's concurring reasons for the majority, they are looking at this very broadly. I think Your Honor suggested at one point that maybe a way of looking at it was a public or a private law divide. And did the minority look more broadly than the majority? And I would absolutely and forcefully argue against that. In fact, when you read these decisions, you see a number of paragraphs and portions of them that talk about very broad ideas that are not a narrow interpretation. Chief Justice Strong talks about, in very broad language, what these treaties were meant to do. He goes through and rejects ideas of liens on lands or proceeds. He considers the broad effect of the transfer of responsibility for Indian matters from the imperial government to the more local government. That's not a narrow legalistic consideration. He talks about not believing that it was the Supreme Court of Canada's role to unravel the arrangements that had been made at Confederation between the colonies that united together in Confederation. Again, these are broad public law matters. It's not a narrow, limited focus. And he speaks as well about the award of 1870 and the broad impact of that award and how it has stood at that point for 25 years. That also is not a narrow private law transaction. It's about the Constitution. So I would commend the full decisions to Your Honor before defining terminology is placed on if they were narrow or not. I think it's something that Your Honor must reach your own conclusion on, if I may respectfully say.
Thank you.
Now, what's also important when you read those decisions is that the Supreme Court of Canada and the JCPC, there's nothing in their decisions There's nothing in their decisions that suggests that they're focusing on a limited amount, a limited $4 annuity, the amount that was increased already. In fact, as I've read to you, and as you've read along with me, the Supreme Court of Canada substituted language says any annuities as well as those agreed to be paid under the condition in the treaties mentioned. There's no reason to think, I submit, that if a different amount was being paid or proposed, that analysis would change. They were looking at the sections of the Constitution and the financial arrangements, provisions that had been entered into. And there's no reason to think that if different numbers were being applied, their analysis of those provisions would change. They apply equally to any amount of augmented annuities.
Can you give me that reference, please? From the quote, any annuities as well as those agreed to.
Yes, Your Honor, that's at page 125 of my compendium, tab 28.
Thank you.
And that's the portion that is ultimately the substituted language for paragraph 6 of the arbitrator's award number 3.
Thank you.
Oh, Ms. Glasser is also pointing out to me that you might be referring to something else that I said as well, which is at the bottom of 124, Your Honor. The arbitrators, again, Chief Justice Strong, the arbitrators must therefore be taken to have had in mind all the annuities, the original fixed annuities, as well as those contingently provided for. That's over the top of page 125.
The arbitrators must therefore be taken to have had in mind all the annuities or original fixed as well as those contingently provided for. And you say that says any annuities as well as those agreed to be paid under conditions in the treaties.
That's correct, Your Honor. That is my position.
Thank you.
I might point out as well that quite a bit of space is spent on this in our submissions, our written submissions. In our main submissions, we explore it beginning at paragraph 133. Goes on until 141. And in our reply submissions, paragraphs 24 through 30.
Thank you.
Now, what other legislatively binding decision has been made in the past that we must consider? And we say that Award 10 is one of those. And this is an award, first of the statutory arbitrators, and then appealed by Quebec to the Supreme Court of Canada. It was dated January 7th, 1898. I'm now questioning if it was January 10th, but it's certainly January 1898.
The date you're giving me is the award number 10.
Yes.
Thank you.
And so we have to kind of place ourselves in history a little bit. I spoke about the order of the same date earlier today. And that was the order about the burden of proof. If you wanted to charge the account, you had to prove. The same day there's an award. And this was following from the JCPC decision, because of course the Supreme Court of Canada annuities case in December 1895 is appealed to the JCPC. It releases its decision in December 1896. All of this seems to have happened very quickly. And then we find ourselves in January 1898. So a little over a year later. And what I said to you earlier today was when that order had been taken out or directed on Canada, the backdrop of that was that Section 109 was off the table. It was off the table because the JCPC had agreed with the Supreme Court, which had disagreed with Canada and Quebec that it was a 109 matter. So Canada then brings another claim, this time against Ontario and Quebec, and says that the post-Confederation annuities owing are 111 matter. And that time the arbitrators agreed with them. And the Supreme Court of Canada upheld that decision. Quebec still fought it. Quebec alone appealed that decision. Ontario did not. Quebec appealed it, and the Supreme Court of Canada from the bench dismissed it. They said that the arbitrators were correct.
Okay, I'm a bit lost. We get the award of, back to see what it is. The annuities case, is that 1896?
The Supreme Court of Canada's annuities case overturning the arbitrator's decision.
Yes.
Let me go back and do it chronologically. Award number 3, with the paragraph 6 that becomes impugned, was dated February 1895. In December 1895, the Supreme Court of Canada releases its decision overturning paragraph 6.
Okay.
In December 1896, the JCPC upholds the Supreme Court of Canada's December 1895 decision.
Okay, so I was just trying to. So you were saying against that backdrop, Canada brought another claim that resulted in award number 10?
That's correct. Now, let me be clear. They don't jump from 3 to 10. There's a bunch of other related statement of account issues.
But we're tracing a particular issue.
That's right.
Okay. So against that backdrop, you have a JCPC decision upholding Supreme Court of Canada decision, and you say that by 1896, the order has been taken out, JCPC, and then.
I may have given a wrong impression there, so let me correct that.
All right, go ahead.
The JCPC decision upholding the Supreme Court of Canada decision has not resulted in an order that I've seen. When I said an order, I was referring to the burden of proof order of January 1898. And I said, I'm going to talk about what happens in January 1898. And 2 significant events happen. One we've spoken about earlier. It's the burden of proof order direction. Ms. Jones was very clear that there was this order and then there was an award same day. An award about the burden of proof, an order about the burden of proof, and award number 10. And what award number 10 says is that for post-Confederation.
Sorry, is the burden of proof award number 10?
The burden of proof.
Using those interchangeably?
No, so, and I apologize because I think I've caused this confusion. There's 2 documents that come out of that day. 2 documents signed, if you will, by the statutory arbitrators. One is called an order. To the extent that it's related to the Robinson annuities, it's related, but it is not an award. The order I will refer to as the burden of proof order. We've talked about it today. It talked about pay lists and proving eligibility to it if you were going to charge the UPC account. Then there's an award. And the award was after a hearing about the post-Confederation responsibility for augmented annuities. Because of course, what had happened was that in Award 3, paragraph 4 had made pre-Confederation a 111 responsibility. 111 and 112, but 111 responsibility. And they had said that post-Confederation was 109, but the Supreme Court of Canada had said, no, it's not. But they hadn't gone further in their decision and substituted in that paragraph, it's a 111. So you've got, if you went back and you looked at Award 3 against the Supreme Court of Canada decision, you'd say, okay, paragraph 4 of Award 3 says pre-Confederation 111, but paragraph 6 now substituted says post-Confederation's not 109. So what Canada does is they come to the arbitrators and say, well, if it's not 109, we want an order. Again, probably because these orders were meant to be binding, that it's a 111. Post-Confederation's 111. 111 and 112. And the arbitrators agree with them. So in January 1898, we see award number 10 saying just that. Post-Confederation, 111, 112.
Thank you.
Now, back, not happy again. This is their right. They appeal it to the Supreme Court. And the Supreme Court, from the bench, dismisses Quebec's appeal. So maybe we look at that for a moment. Tab 22 has the Supreme Court of Canada's decision on appeal from Award 10.
I thought you were going to, I'm following you. I thought you were going to take me then to the JCPC.
No, the
No.
JCPC hears an appeal from the Award 3 Supreme Court of Canada decision.
Nothing, no appeal from the Supreme Court decision.
No.
Thank you.
So when I say that it is legislative, when I talk about what awards and what decisions are legislatively binding, I would say that Award 10 of the Supreme Court of Canada is legislatively binding. It affirms the decision of the arbitrators on Award 10 with respect to 111, 112 being a post-Confederation issue. But because the statute of 1891 says the final award of the arbitrators in writing shall be binding unless appealed, I'm just pointing out that that final appeal decision is now the Supreme Court of Canada, and it is legislatively binding as a result of the Act of 1891.
Thank you.
Is there any other help I can give you on that, or does it seem clear as mud? Okay. So, as your honor has noted, nobody appeals that to the JCPC. So that stops at that point. Now, there's no legislative exceptions to the binding force of these awards. Okay? There are exceptions under the common law, and I will explore those with you shortly. But there's no exceptions to the legislative binding force. In this respect, the legislation trumps the common law. And it renders that Canada is bound by the decisions.
What common law is it trumping?
So I'm going to turn to that next, because there's two doctrines of common law that if there was not a legislation, if there was not an act in force that said that these decisions are binding on you, as you know, common law decisions of judicial courts of courts are subject to res judicata and stare decisis, but there are exceptions to those that may apply in the appropriate circumstance.
So that's what you're talking about.
So those are the common law principles that I wish to turn to. Because
Say they trump common law, you're also arguing, aren't they? They are consistent with?
yes.
Okay.
Well, I would say that, yes, they're consistent because you should not apply an exception to those common law principles, and you should uphold those
And you
decisions.
say that because you say they don't fit within the exceptions too.
That's right.
So they're consistent with your interpretation of the common law.
That's right. So I'd like to turn to that next, if I may.
Thank you.
So stare decisis and res judicata are the two principles or doctrines that I wish to talk about next. Stare decisis, as I know your honors aware, binds trial courts to follow the legal findings of higher courts, in particular the Supreme Court of Canada and the JCPC, especially where those earlier decisions address the same issue as the lower court finds before them. Sorry. Now, there are two exceptions to stare decisis. One is where a new legal issue is raised. The second is when there's a change in the circumstances or evidence that shifts the parameters of the debate. And we say that neither applies here. So I want to talk first about the no legal issue, no new legal issue being before you. Canada has made submissions to you this week and last Friday that the Supreme Court of Canada addressed the very same legal issues that are before you now. She said that this has all been argued over 100 years ago. We agree with her. Then, as now, Canada argued that Ontario's lands were burdened by Section 109 interest or trust. The courts disagreed. Then, as now, Canada argued that 111, Section 111 of the Constitution, the British North America Act, did not apply because the obligation to pay augmented annuities arose after Confederation, a contingentness. The courts disagreed. I took you to the passage of Chief Justice Strong where he very particularly said that he disagreed. And I've submitted to you that there's no reason to think that that decision would be different if we were talking about different amounts. They were analyzing and interpreting the financial deal of Confederation and what it was meant to achieve. And they made, we say, binding findings of law on that basis.
And now I take it you're only speaking to the cross claim
This is about the cross claim, Your Honor.
only?
Yes. The Crown allocation dispute for us is as between Canada and us.
Yes.
That's because we say that this deal at Confederation made Canada the person to go to for direct liability.
But you don't make a stare decisis or res judicata argument with respect to the cross to the plaintiff's claim.
We do not.
Thank you.
So we say then that there are no new legal issues to attract the exception to stare decisis. We also say that there hasn't been a change in circumstance or evidence that attracts the exception either.
And you don't say that the stage 1 decision in the Court of Appeal decision is a change of circumstances?
No. It's still about the treaty language. And as between the crowns and who pays, it's about the constitutional provisions. So this is an issue between Canada and Ontario. With respect to the 109, and I'll get to this in a bit, my friend has said it's not his fight. This is an issue between Ontario and Quebec, or sorry, Ontario and Canada.
It's not what?
It's not the fight about 109 is these constitutional provisions. 109 is not a claim that he is relying on. He's not relying on that. The plaintiffs are not. This is about who pays the obligation that the Constitution, we say, created. We're not raising res judicata against my friends for the plaintiffs. Stare decisis doesn't require the parties to be the same. Res judicata does. I'll deal with that momentarily. But the fact that the plaintiffs are here today is not a change in circumstance as it relates to the payment dispute between Ontario and Canada. Stare decisis binds Canada, and we're not claiming it as a doctrine against the plaintiffs. Crown allocation dispute is based on the same treaty language and constitutional provisions, none of which have changed. It's not a new treaty in that sense. The issue today between the crowns, who pays, who's responsible for this direct payment? It's the same issue that was before the Supreme Court of Canada and the Judicial Committee of the Privy Council. Now, Canada argues that the Stage 1 decision and the Ontario Court of Appeal decision changes this. As I understand their argument, they say that the Supreme Court of Canada and JCPC's decisions were based on a narrow interpretation that the augmentation clause is a matter of grace, purely a matter of grace. Canada cites no passage of the Supreme Court of Canada's decision to support its position that the Supreme Court was looking at the treaty so narrowly. I've taken you to some of those provisions and I've commended you to yourself do that analysis. But none of the Supreme Court of Canada judges describe the clause in that manner. They do not suggest that augmentation only equals grace. In fact, the two judgments, the two reasons of the majority decision, Strong and Sedgwick, because of course Taschereau joins them but doesn't write separate reasons, refer generally to augmentation as an obligation. And the Judicial Committee of the Privy Council, the JCPC, doesn't narrowly look at it either. They don't even use the word grace except when they set out the augmentation clause itself. Lord Watson was speaking of where payment of original versus increased was to be derived from the same source. He was considering whether there was an exception or an obligation. He decides that there's an obligation. He doesn't narrowly say that it's a matter of grace. Now, Canada relies on paragraph 48 of the JCPC decision. Might be helpful to turn that up. Let me find the reference. Tab 31. There's two different copies of the JCPC decision being used, and the paragraph numbering is a little different in each, so. Of ours. Oh, this is fine. Pardon me, Your Honor, I can't read my own handwriting. If you're looking at tab 31,
Yes.
it's paragraph 15 Sorry, Your Honor, I need a minute.
Yeah.
You had it, and I can't see it. Go. Excuse me, Your Honor. I'm at tab 31, paragraph 16, and it's the second sentence that begins the promise and agreement.
Thank you.
Now, this phrase must be taken in its context. And because of that, of course, as I've already said or suggested to Your Honor, the case must be read in its entirety. But here, Lord Watson, on behalf of the unanimous JCPC, is making a distinction. He's differentiating between a property right, such as those in section 109, and a contractual right, such as those to which section 111 applies. So they're simply, but I would say importantly, concluding that the plaintiffs received no section 109 interest in the treaty territory. They don't say anything about the augmentation clause being a matter of grace. Now, I would like to address some of my friends' submissions about those decisions, the Supreme Court of Canada's decisions and the JCPC decisions being based on outdated principles.
And I just tell you, there's language here that maybe you can help me with. When you say they weren't taking narrow interpretations, I just note two bits of language here. One, this reference to the treaty having language of an ordinary mercantile transaction.
Yes.
A concept that has been soundly rejected.
Yes.
In stage one and by the Ontario Court of Appeal. There's nothing ordinary or mercantile or transactional about it.
Well, that comments
second,
also, sorry.
The language in paragraph 16, where the writers say, why in these circumstances a liberal construction should be resorted to, we are at great loss to understand. The so-called equity, talk about equity to the treaty beneficiaries, the so-called equity appears to have been conjured up for the doubtful purpose of construing provisions of section 109 with a liberality which the ordinary canons of construction do not admit of. So I just put those to you in what appears to be contradiction to this notion that they were not looking at the interpretive task before them as a narrow one.
Let me address both of those in turn, Your Honor. Respecting the ordinary mercantile transaction. With respect, we need to look again at the context. What the JCPC said, I think I've actually had it highlighted at paragraph 15. Their lordships venture to doubt. Well, they go on to talk, let me go back. They begin the paragraph speaking about what two of the learned arbitrators did in their decision, in the discussion to the award. And then they go on to say, their lordships venture to doubt whether the treaty has any application to those parts, even of a proper international treaty. Now, in my respectful submission, that comment is obiter. That comment is obiter. The JCPC was doubting the applicability of an interpretation principle that two of the arbitrators employed in reaching their conclusion. But the lordships of the JCPC, they don't reach a conclusion on that issue. They express doubt about the arbitrator's approach. That's what that again, the context of the entire decision rather than these sound bites. It needs to be read, but they were expressing concern and doubt about an approach that the arbitrators were taking. And with respect to the idea that the JCPC shunned a liberal construction of the treaties, the passage that you read out, I was actually planning to take you to, because here we see that they're not actually shunning a liberal or a more broad construction of the treaty. What they're doing is actually applying a modern day principle today. They're applying a principle of treaty interpretation that's been endorsed by the Supreme Court of Canada in Marshall, and which you used, I believe, Your Honor used in paragraph 324 of the Stage 1 reasons, where this court said, while construing the language generously, the court cannot alter the terms of the treaty by exceeding what is possible on the language or is realistic. That's what the JCPC is talking about here. It's not shunning a liberal interpretation or instruction. It's just saying you can't go outside the language of the treaty. So in fact, we say there's no change of circumstance, and there's certainly not a change in circumstance in respect of outdated principles. The JCPC's decision is entirely and directly in accordance with more modern contemporary principles. It's also important too that, these decisions, stare decisis, the exception, if it applies in this case, there are other foundational constitutional decisions and arrangements that sort of collapse. One is the Yule Bridge decision. You've heard about the Yule Bridge. It was one of the statutory arbitration matters. Ms. Jones talked about it. It's a decision that I've included at compendium tab 39. It was a decision involving, not surprisingly, a bridge. It's a decision that was dated October 1899. So after this JCPC decision, and after the Supreme Court of Canada annuities case that the JCPC decision upheld, and there Canada made a similar argument about Section 109 that it makes in the annuities case and made then and is making now. The bridge in question was in Quebec. It was built in 1845, and it became in the jurisdiction of Quebec at the point of Confederation. And there was a weird clause in it. It was free for a while and it was being leased, but the important point for our purpose is that 50 years after it was built, Mr. Yule was to be paid. So it's built in 45, prior to Confederation, but the amount to be paid for it is post-Confederation. You know where I'm going with this, right?
Public-private partnership.
Yeah. So Canada argues that Section 109 is applicable. You've got this benefit, it's in your territory, and it was not a liability that existed at the Union. And guess what? There, the Supreme Court of Canada said, no, referring back to the Supreme Court of Canada's annuities case, a contingent liability that was known as a possibility at Confederation is a Section 111 matter. So these cases, as you know, this is how our rule of law and judicial system works. They build on one another. There's also the decision of the Judicial Committee of the Privy Council in 1910. That's a case of Canada and Ontario again, and it's about Treaty Number 3. It's at, excerpts of it are at tab 34. Now, you've heard also about treaty number 3 and about how the Northwest Angle Treaty number 3 was one of those issues before the statutory arbitrators that they couldn't decide on. So it's made without prejudice, some of those awards, because it's still being litigated. Now it goes all the way to the JCPC. And there, Canada argued that Ontario was responsible for Treaty 3 annuity payments because Ontario had the land. Now, the JCPC disagreed, and it referred to the statutory arbitration award number 3. It noted that the Supreme Court had reversed it, and specifically that it had determined that the liability for annuities didn't follow the land. If we look at paragraph 1 of the 1910 decision, page 144 of tab 34, we see this reference that I've described. We see Lord Lorbourne, LC, saying, referring to the proper proportion of annuities and other monies about matters. And he says, he talks about Justice Burbridge. He actually says Burbridge. On appeal to the Supreme Court of Canada, 3 out of 5 learned judges reversed that decision. The various opinions delivered in both courts have dealt with the case so exhaustively and so clearly that nothing new really remains to be said, and the matter at issue has been reduced to a simple, though extremely important point. So my point here, in case it's lost on you, is that these decisions bind Canada, but they also, they stack on top of each other. So they are not narrow decisions that we can say are outdated, because if we do so, we are collapsing a whole body of work of constitutional arrangements that have been made and decisions that have come after. I wonder if this might be an appropriate time to break for the afternoon.
Thank you. Thank you.
Put us down for 15 minutes. Court is resumed. Please be seated.
Justice Hennessy. I hope it provides you some comfort that I think I'm almost done. And if I'm almost done, then we are on time.
Excellent.
I take no responsibility for what the rest of them do, though. I am on
Not
time.
quite throwing you under the bus, counsel, just.
I am on time. All right. So I wanted then to talk to you about Canada's argument to you that the fact that there are different parties before you make a difference, and that that is an exception to these common law doctrines that I've been discussing with you. Canada has submitted, as I understand their argument, that these decisions cannot be binding because the plaintiffs were not present. There was some submissions
Binding on Canada.
Yes, I'm only speaking about these arrangements under the Constitution, that there's direct liability to Canada and the cross claim as between, or by Canada against Ontario.
Mhm.
So I will try to emphasize that, but please do take my submissions that way.
Thank you.
I understand Canada to have argued as well that had the First Nations been present, there would have been a different decision. And in fact, there would have been a finding that they would have had a Section 109 interest. Now, I say that that's speculation to you. They were not there. They are here now. But they're not here now claiming a Section 109 interest. In any event, for stare decisis, the non-present of the plaintiffs in the earlier cases is irrelevant. That doctrine binds everyone to the same determinations of questions of law. Same parties is not a requirement. It is a requirement for res judicata, so let me address that next. In our res judicata pleadings, Your Honor, if I may give them to you. You'll find those in our statement of defense generally at paragraph 76, 78, 81, and 82, and against Canada as the defense to cross-claim at paragraphs 11F, 14G, and 17C and D. Cause of action is pled the statement of defense, paragraph 8. Issue estoppel is pled generally at paragraph 49 of our statement of defense, and as against Canada and our defense to cross-claim at paragraphs 14G and again at 17C and D. D is in David. The res judicata, as I know Your Honor's familiar with, has two branches: cause of action estoppel and issue estoppel. There's also the related doctrine of abuse of process. That, of course, prevents the relitigation of issues where the two more structured doctrines do not apply. We say all of these apply to Canada's cross-claim because Canada is asking this court to find that Ontario's lands or proceeds within the treaty area are subject to a 109 interest. And all of these legal issues were argued by Canada more than a century ago. It lost them then. It should lose them again now on the basis that there's already binding decisions. Supreme Court of Canada and the JCPC has definitively said that Section 109 does not apply. The essence of res judicata is that a party gets one attempt to convince the courts of its position on an issue. If it fails, it doesn't get a second. And with respect, it doesn't get to pick what reasons for decision it likes and suggest that that should now apply 100 years later. That's not how the doctrine works. So Ontario submits that the plaintiff's non-participation in those earlier decisions don't matter. They do not matter for two reasons. The first, as I've said already, while Canada attempts to reopen that issue of a Section 109 interest in the treaty territory and relating to the augmentation clause, the plaintiffs are not. I heard my friend, Mr. Schachter, last Tuesday, September 12th, advise the court that it's not our fight. That may be between Ontario and Canada, but it's not ours. Second, Ontario is not asserting res judicata against the plaintiffs. It's irrelevant that they were not present at those earlier cases because we do not claim that those earlier decisions are res judicata as against them. But Canada was present. We know this. That's trite to say. It argued these issues fully, forcefully. It was highly motivated to win them because winning them meant that it didn't have the direct liability under Section 111, but Ontario did, but it lost them. Cause of action, of course, a cause of action estoppel, of course, requires you to bring up everything that you could have. So if it now is claiming that there are portions of the award of 1870 that don't apply to it because it was talking about claims of one against the other province, that could have been brought up in the 1890s. And in any event, it's been found to be constitution as a part of the Constitution. There's no conceivable reason, we say, why it should be given an opportunity to argue these issues again 100 years later.
I'm just seeing if I've got what you said. You say cause of action estoppel requires you to bring up everything you could have,
That's right.
every issue.
Every issue.
And do you say Canada had an opportunity to bring up the issue that the augmentation might be unlimited? Well, I'm not sure what you're pointing at if you are.
One of Canada's arguments, as I understand it today, is that clause 13 of the award of 1870. There's two portions to that clause. It says the constitutional arbitrators, the section 142 appointed arbitrators, say that Indian annuities, without limitation, I took you to that language, and Chief Justice Strong's language as well, specifically says it was without limitation. Indian annuities form part of the debt of the province of Canada existing at the Union. Then there's another portion of the clause, and it talks about the lands and the claims as against one province and another. And Canada's saying today, well, clause 13 doesn't apply because that's just one province against another. And I'm saying, well, hang on. The award of 1870 does apply. And the whole portion of it applies. It's a binding decision, but also the Supreme Court of Canada has said that it forms part of the Constitution itself. And that makes sense because the arbitrators were appointed to do a particular task specifically under the Constitution, and they did it.
That's the background to why it should apply, but I'm trying to figure out what you say is the term that Canada could have raised then.
Let me answer that more directly then. To the extent that they're saying, well, these are just claims of Ontario and Quebec as against each other, and it doesn't somehow include a claim by Canada against Ontario. So this is not something new, or this is something new.
You're saying Canada says at the time, or now, Canada says now that that award is an award as between Ontario and Quebec.
They're saying that that portion of it is limited to claims as between Ontario and Quebec because of the language of it. And I'm saying, no, that clause speaks about debts of the UPC being public debt. That's absolutely about Canada. Canada that has the public debt responsibility. But also I'm saying that even if they were correct, you have to bring everything up that you can. And we had a number of our,
as in every legal issue?
yes,
Okay.
that's possible too.
Yes.
You can't hide in the weeds and bring it up at some later date. And this is not, we haven't gone from 1870 to 2023. There's been a number of judicial and arbitral decisions between now and then that could have been raised, and it hasn't been. And if it had, perhaps it might have impacted those decisions that it's a 111 issue. I say it wouldn't have, but I'm also saying that cause of action stops them from bringing it up now because it could have been brought up then. It's a cause of action that could have been brought up then.
Why would it have had to bring it up then? If it was in fact a dispute as between the provinces, between Ontario and Quebec?
Because in the subsequent arbitral decisions, what was happening was that Canada was bringing claims for statement of account matters. And to the extent that I understand their argument right now, to the extent that I understand it right now, it's that they're saying that what was found by the arbitrators of 1870 to be Indian annuities being a debt of the province of Canada, ergo Section 111 applies. That's the only thing the debt of the province of Canada applies to under that legislation. That's the specific language that's used. So to the extent that there seems to be, and if I've misunderstood them, then that's on me, but to the extent that they seem to be suggesting that the rest of that clause is only meant to talk about claims between Ontario and Quebec, the fact is that we now have all of these arbitral decisions where they were also claiming that Section 111 didn't apply, Section 109 applied, and they could have pointed to that decision and made that argument then, but they didn't.
They could have pointed to
Clause 13 of Award of 1870 and said, oh no, 111 doesn't apply if it only applies if it's a claim between Ontario and Quebec. But that doesn't make sense because the debt is something that Canada is taking on and that Canada then is charging the UPC account for.
Let me make sure I've got this. Canada could have pointed to clause 13 of which award?
Clause 13
Yes.
of Award of 1870, the final September 3rd, 1870 award of the Section 142 arbitrators.
Thank you. Which we also call that 1870 award.
I call it the Award of 1870. I think I might have also referred to it as the final award of the Section 142 arbitrators.
Thank you.
And that's the award as well, of course. So just because I know there's a lot of decisions, but that's the award that I took you to. And the clause 1 is the apportionment. Right? And then at the end of our evidence, we read in answers to interrogatories that had been passed between the parties. And we read, and I don't have it with me right now, I can get it. But Canada had agreed that that award had set those apportionment values or ratios or percentages, and that there was no change that could be permitted to those particular percentages. So I plan to now move off of the common law.
I just have one question here. When you say that Canada argues that the absence of the First Nations is a fact to consider when one considers that there might have been a different result. And am I correct? I say that your answer is there's no proof of that?
It's speculation.
Speculation.
Of course,
But isn't that the whole idea of the exception to a decision being binding? You don't have to prove that there is, that there would be a different result. Of course, it's speculation. You don't know what the result would have been. Sadly, humans make the decisions.
Well, I think it's particularly telling that the plaintiffs are here today and they are not saying a Section 109 interest applies. They're not claiming that. So for Canada to say, well, if they had been there way back then, of course, it would have been found that there was a Section 109 interest. Of course, it's speculation, and I agree with everything you just said about speculation. However, I think it strains credulity to say, well, had they been there, they would have gotten something that they're not asking for today when they are here. So let's not forget that Mr. Schachter was very clear and might say, they're not looking for that. So I plan now, unless you have further questions, Your Honor, to move off of those common law doctrines and to explore with you, I think more briefly than what we've discussed so far, what I called the third point, the de novo point. Now, I said earlier to you that I see this as a domino effect. If you decide that Award 15 does not govern the way we say it does, then you need to look at the Constitution. And if you then look at the Constitution and you say that these decisions do not mean what we say they do, or that they do, but that matters of res judicata and stare decisis don't apply because of exceptions, then you have to look at this issue de novo. It's our submission you should not. These are a body of work of courts for many years, stacked upon one another, and many cards would fall from the house if you pulled one from the bottom. But it's our submission that if you look at this de novo, the same conclusions must be reached today as the Supreme Court of Canada and the JCPC reached when they conducted their analysis. With respect to Section 109, there is nothing in the treaty language that suggests a Section 109 interest. The augmentation clause is about annuities. It's about the right to annuities. Section 109 is about property rights. The augmentation clause only specifies an event, positive net Crown resource revenues that will trigger an obligation to augment. It does not say that the augmentation must be paid from the treaty area's proceeds. There's no logical reason we submit to you why augmentation would have to occur directly from proceeds. There's no reason to think that the Crown would have agreed to pay augmentation in that way. And you've heard the evidence that they had historically, up to the time of treaty and beyond, paid them from the CRF. Second, again, still on 109, the plaintiffs already had the solemn promise of the Crown. The Imperial Crown, as I said earlier, likely the richest nation in the world at that point in time. They had the solemn promise to pay the augmented annuities. They did not need a further security interest to ensure that they would be paid. And Chief Justice Strong made that point directly. Took you to that passage. I will remind you that it's at tab 28 at page 503 of the decision itself, but let me read it to you. The Indians had therefore the highest security which could be given for the payment of the augmentations, the assurance and covenant of the imperial government. There was therefore no reason for giving or implying any other. A security payment or a security interest, of course, it's necessary when there's uncertainty about whether a party will have the ability to make its required payments. There's no such uncertainty when it comes to the Crown, and certainly not the Imperial Crown at the time. No other security interest was necessary. The third reason is that Section 109 allows for an interest to exist regarding provincial land and provincial revenues. It plainly does not capture federal revenues. Now, my friend said that common sense would apply and that federal revenues would be captured somehow. But Your Honor said, and I may submit correctly, that this needs to be grounded in law. And Section 109, the law of the Constitution, makes that section about provincial revenues. And we say that were you to determine de novo that the treaty created a Section 109 interest in the proceeds from the land, that would relieve Canada of any liability. Would relieve them for all time of sharing the value of its own resource revenues with the plaintiffs. That can't be correct. The plaintiffs have claimed such revenues are captured by the treaty. Canada, in fact, conceded that there may be future unknown federal revenues that might fall within the treaty promise. I think my friend Mr. Schachter referred to Mr. Tesla. And we've heard an awful lot about spectrum. All of these ideas and new revenue sources that may or may not be captured under this augmentation clause. My point is that in 1850, they couldn't have been imagined. So what in 2023 can we not yet imagine? The treaty, of course, has a long life. Fourth, it is not likely that the Crown would have agreed through the treaty to create such an interest in the proceeds. As the JCPC reasoned, it would have been a considerable inconvenience to the United Province of Canada that was focused on settlement and expansion to have a burden with a Section 109 interest still there. Such an interest would have made those revenues unusable by government unless or until the Section 109 interest was discharged with respect to those revenues. So it's our submission, if you're considering this de novo, you have to consider and conclude that it would be unlikely the Crown would have agreed to have resource revenues burdened by such an interest. We'll turn to Section 111 de novo then.
Let me just catch up for a moment, please. Are you saying that finding of Section 109 would run with the land, that burden would have run with the land?
Mm-hmm. Yes. It would have to be discharged. The treaty lasts forever. How would that conceptually work?
Okay. Go ahead.
So I noted earlier, turning now to Section 111. Of course, I pointed you to the paragraph of Canada's main submissions, 309, where they concede that they're liable for pre-Confederation augmented annuities due to Section 111, and I hypothesized that that might also be a concession based on these decisions. So any award that this court issues must take that concession into account. For the years between 1850 and 1867, Canada's conceded that it's liable. Of course, Canada argues that it's not liable for post-Confederation augmented annuities because those amounts didn't crystallize until after Confederation. Section 111, we've seen it already today. It says that Canada is liable, shall be liable for the debts and liabilities existing at the union. It does not say crystallized debts, crystallized liabilities, and the treaty created a perpetual obligation on the Crown to pay augmented annuities whenever Crown resource revenues were such that those augmented annuities could be paid without incurring a loss. Now, this obligation was a debt which Justice King, one of actually the minority judges at the Supreme Court of Canada annuities case in 1895, he quite sensibly, I suggest, described as including all forms of indebtedness, whether ascertained or unascertained, determinate or indeterminate. And of course, I took you to the language of the Supreme Court of Canada's decision where they substituted paragraph 6, where they said it was any annuities, whether realized or not, contingent or otherwise. Justice King further noted, you can look at this, it's at tab 28. This is the Supreme Court of Canada case again. Justice King, at page 129. In the last paragraph that I've highlighted, he's been talking about the word debts and liabilities in section 112. And he says, this general word debt may very well include all forms of indebtedness, whether ascertained or unascertained, determinate or indeterminate, except so far as particular provisions of the Act impose a limitation.
Let me just get that, please.
Now, certainly Justice King is there talking about the Constitution. Canada has generally supported Justice King's decision with respecting the treaty. But I just point out that even the minority thought it's not just Justice Strong in the majority, but the minority, one of the minority justices also believed that debt did not have to be crystallized. It did not have to be certain. It included a contingent liability, such as the obligation under the treaty. I provided you as well, and I know that the idea of crystallized debt will be explored with you further by my colleagues, but at tab 32, we've included the McClarty case.
I'm just I'm having a hard time keeping up right now.
Excuse me, Your Honor. Where did I lose you?
I'm just at the paragraph of Justice King, so I'm not too far behind. Thank you. Go ahead.
Thank you. I was about to refer you to the Supreme Court of Canada's decision in 2008 in McClarty. And I just use that because it also talks about a contingent liability. and what exactly that is. At page 139 of my compendium, paragraph 17 of the decision. The Supreme Court of Canada says that the well-accepted test for contingent liability was described by Lord Guest in Winter and Inland Revenue Commissioners, a House of Lords decision of 1963. A contingent liability is a liability which depends for its existence upon an event which may or may not happen. The treaty contained and created a contingent liability for the UPC. The resources may or may not perform in a certain way, but there was an obligation, there was a liability to do something, to make a payment, to increase if they did. It's a contingent liability existing at the union. The contingent liability to pay augment annuities to $4 is no different than the contingent liability to pay more than $4. The obligation arises from the same treaty language, the same augmentation clause, the same triggering effect. Resources had to perform in such a way to allow a contingent liability to increase to $4, and they have to keep performing in that way, more so, to pay more than $4. Finally, I want to turn to the last point that I wish to speak of, and that's what I called the division of powers point. It's our position that under the division of powers, Canada is responsible for matters relating to Indians, Section 9124, which we all know well. The historians testified before you in June that the responsibility for Indians were kept with the central strong government because it was a matter of national importance. This was the reason why it stayed with or it went to the central federal government rather than staying with the individual provinces to address and to exercise as they might see fit. Now that's important, so I'm going to tell you in our compendium where the testimony is. Professor Messamore spoke to me about it. Compendium tab 37, our pages 188 and 189. And Ms. Jones spoke about it at compendium tab 35, page 149 through 151. So they say what I've told you, but I'm giving you those so that you know it's not just me. Don't take my word on it. Canada has embraced this role exclusively and consistently since Confederation. It is, we say, the treaty paymaster. We also say that this role is not unique or novel to the Robinson treaties. It's been their consistent position for all historic treaties that it pays directly to the treaty beneficiaries any treaty payments that are owing. Even for Treaty 9 in Ontario, speaking only of the Ontario experience, where Ontario reimburses Canada for the cost of treaty annuities, Canada pays the treaty annuities directly. Canada is the treaty paymaster, even if a substantial portion of the annuity costs is reimbursed. sections of the provincial division of powers do not answer the question of who is liable for paying treaty annuities. Now, I want to respond to my friend's submissions that Grassy Narrows is something that you need to give sober thought to. They submitted that Grassy Narrows, otherwise called Keewatin, makes Ontario directly liable for treaty annuity payments. That's not what that case says, and it's not the principle that can be applied in this case. So Supreme Court of Canada and Grassy Narrows was not addressing whether the division of power provisions applied instead of the financial provisions of the Constitution. It didn't address that issue because that issue didn't arise. The leading case on the issue is an older case, not surprising, of the Judicial Committee of the Privy Council. It's called St. Catharines Milling. Your Honor might have some familiarity with it. Our submissions on St. Catharines Milling are set out in our reply, beginning at paragraph 39 and following. St. Catharines Milling is set out itself, or portions of it, at tab 33 of our compendium. This was a case, again, considering treaty number 3. And treaty number 3, of course, includes lands that are in Ontario. And the issue there was whether or not, who is going to pay given that they were in Ontario. And the Judicial Committee of the Privy Council determined that the general division of powers provisions in the Constitution Act do not govern when financial provisions of the Constitution provide an express answer. And I say that's applicable here.
General division of power applies.
No, when you're dealing with a financial matter,
Do not govern.
you do not look to the division of power because there are specific provisions in the legislation that address financial arrangements. And this is why I've come full circle on the constitutional arguments, Your Honor, and we spent so much time about what those financial provisions were, because they are explicit. They were negotiated, they were thought out, and they were enacted to provide a full answer of what happens and who is responsible when there is a financial dispute.
Let
Now,
me just see if I get that. Are you saying that the division of power provisions were negotiated, thought out, enacted to provide a full answer, or that the arrangements following Confederation up to the arbitrator awards were negotiated and provide a direct answer?
neither. Let me slow down and go back. I'm saying that the financial provisions in our Constitution were negotiated and enacted with intent. And then I'm saying that Grassy Narrows,
Which sections are you talking about?
102 through 118.
Okay.
But in particular for this case, 109, 111, 112, how the 111 and 112 impacted the subsidies in 118, how 111 and 112 were created because 102 was being created, and all of those heavy, important revenues were going to the Dominion and leaving the provincial coffers. So therefore, they took the debts. Grassy Narrows is an important case for the division of powers, and it impacts the treaty in other ways, but it doesn't impact the financial aspect of who pays treaty annuities. In that case, in St. Catharines Milling, back to St. Catharines Milling, Canada was arguing in that case that 9124, Section 91 sub 24, gave it ownership of the Treaty 3 lands. It had ownership over lands that were in Ontario, and it could deal with those lands because there was a treaty that surrendered those lands to the Crown. And the Privy Council disagreed and said, hold up. Section 109 gives that ownership to Ontario. To the extent that there's financial provisions, that's within the financial side of things, not the division of powers. So if we look at tab 33, this is the St. Catharines Milling case. And I'm looking at the bottom of page 141, paragraph 15. JCPC says, their lordships are unable to assent to the argument for the Dominion founded on section, they say 9224. I submit to you that's a typographical error. There is no reason for that, given 14, paragraph 14 is talking about 9124, as is the rest of the case. There can be no a priori probability that the British legislature, in a branch of the statute which professes to deal only with the distribution of legislative power, intended to deprive the province of rights which are expressly given them in that branch of it, which relates to the distribution of revenues and assets. So we say that what the Judicial Committee of the Privy Council decided in St. Catharines Milling is that when you have provisions that deal with financial matters, you use those provisions. You do not look to the division of powers. That's not what was intended by the British legislature when they passed the British North America Act in 1867. This is just an expression, the general principle of statutory interpretation, that a specific provision, in this case, specific financial provisions, prevails over general provision. Here, sections 109, 111, and 112 are specific provisions that directly address financial matters and obligations for liabilities. The decision in St. Catharines Milling is itself stare decisis, as against everyone, certainly in that case, between Canada and Ontario, and it's res judicata, as against Canada and Ontario.
As per the doctrine of stare decisis.
Yes, and res judicata as well. To the extent that there is an issue of which provision applies, and if the division of powers applies to financial obligations, the answer is no, it does not. Canada has not responded in its written reply submissions or orally that Canada is bound to this decision. We say it has not because it cannot. It is bound. It is a final determination. Your Honor, those conclude the remarks I wish to make to you about Crown allocation. As I indicated to you yesterday, my colleagues do have some other matters about Crown allocation, but they will primarily be focusing on the economic response. I notice it's almost 4:20. I do understand my friend, Mr. Wong, is prepared to proceed, but I might suggest that by the time I get out of the way and he comes up, we're going to be pretty close to 4:30. We're in your hands.
Very good. Let's end the day, but perhaps I can hear you on Ontario. Are you? I think you're meeting your anticipated schedule, that you'd be on your feet today, Ms. Barkley, and that what is left in points 3 and 4 are anticipated to be covered tomorrow.
As I said yesterday, Your Honor, I did anticipate to be a full day, and I meant that to be the 45 minutes left to me yesterday and today. Just want the record to show that I was very good with that.
The record is very,
I am often accused of not being on time. I am on time. But then I did mention as well that we had originally planned to be 2.5 days, and that might bleed us a little bit into Monday. I cannot speak for my colleagues, and I will say in discussions, of course, we've had as a team, they're hopeful to wrap up tomorrow, but we may bleed a bit.
thank you. And how does that make it look for you on your side, Mr. Schachter, Mr. Gover?
For the plaintiffs, that looks marvelous, and we'll be able to start on sometime on Monday. And if we don't finish on Monday, we would finish on Tuesday.
Very good. And Mr. Gover is nodding his head on that.
I am, and now I'll do it at the microphone. Thank you.
Nodding your head at the microphone makes a big difference. Very good. All right, we'll break now until tomorrow at 10. Thank you.
All right.
Oops, I'll stay.
This court is adjourned until September 22nd, 2023 at 10 a.m.